stated earlier, the second accused called two witnesses. The first one being Mr. Obado, who testified as the defense witness. This witness admitted that he was at the time serving as one of the first accused bodyguards, and that he had served him in that capacity for 10 years. He also admitted he admitted knowing Olivia, that is the third accused wife, but denied having attended a meeting in her home on the morning of that September 2018. He denied that he knew Sharon, claiming that he only learned about her after her death. The second accused, second witness, Mr. Patrick Angamwangi, testified as defense witness 4 and claimed that he was the principal officer in quantum auto assessors and valuers, a firm dealing with accident assessments and valuation of vehicles. He gave his qualifications as a diploma in automotive engineering from the Kenya Polytechnic and a certificate of proficiency in insurance from the College of Insurance. This witness recalled having received instructions from the law firm of Professor Tom Otieno and Associates, seeking expert opinion on the likely consequences of a person who was of average height with a lean and athletic body, jumping from a vehicle moving at a speed of between 80 and 100 kilometers per hour, landing on the tarmac. After researching on this brief, he formed his opinion that such a passenger would be expected to sustain extensive and severe injuries, including fractures and death. He documented his opinion in a report he produced as a defense expert. Upon being examined by his security officer, he admitted that his expertise was only limited to motor vehicle assessment, but not medical injuries in the kind of scenario referred to him by the second accused advocates. He also admitted that before preparing his report, he did not conduct any demonstrations, simulations, or reconstructions of the scene using any devices to determine possible outcomes. He instead relied on sketches that he did not produce before the court. The third accused testified as a defense witness 5. He also denied having committed the offense as alleged, but he admitted that in the year 2018, he worked at Migori County as a clerical officer, and that Olivia was his second wife and owner of motor vehicle registration number KCL 41K. He claimed that he denied that he was at Olivia's home during the day, claiming that he spent the entire day at his place of work and only went to her home in the evening. He further testified that he met the late Sharon, only once, when he accompanied the second accused to a meeting in Homa Bay town, in which the deceased was a participant. He added that he did not have any personal interactions with Sharon and did not even know about her relationship with the first accused until he read about it in the social media. He, however, did not clarify whether this was before or after Sharon's illness. The third accused also denied having contacted PW22 on the 1st September 2018 or requesting him to procure false medical reports for the second accused. He also denied having seen the second accused on that. Upon cross-examination by Ms. Lecoy for the prosecution, accused 3 confirmed that between 2013 and 2018, he was based at the Migori Governor's office. He also recalled having accompanied the second accused to Capital Center on the 24th of August when he had gone to meet Sharon on PW9. He also confirmed that in his statement to the police, he had admitted that he was at Olivia's wife. He was at Olivia's home, that is his second wife's house, on the 3rd September 2018 at around lunchtime or around midday. In addition, he confirmed that Mr. Gombe, PW38, had been the driver of the subject vehicle, that is KCL 4, since it was bought by his wife in 2017. After the close of the defense case, landed counsel on record for the parties filed lengthy and very elaborate final written submissions, which I have duly considered, together with all the authorities cited. And having carefully considered the evidence adduced by the prosecution and the defense in this case in its entirety, together with the written submissions filed on behalf of all the parties, I will find that the only issue arising from my determination is whether the prosecution had proved to the required standards required by the law that the 3 accused persons, whether by themselves or jointly with others not before the court, murdered Sharon Otieno is alleged. The offense of murder is created under Section 2 or 3 of the Penal Code, which stipulates that any person who of malice aforethought causes death of another person by an unlawful act or omission is guilty of murder. A plain reading of the above provision reveals that the offense of murder has 3 essential ingredients, which the prosecution must prove beyond any reasonable doubt before it can secure conviction. The 3 ingredients of this offense have been identified in numerous authorities, which I will not rehash here. It will suffice to cite the authority of Anthony J. Wagari versus Republic, in which the Court of Appeal held as follows: that the 3 elements of the offense of murder, which must be proved beyond reasonable doubt, were as follows: the death of the deceased and the cause of that death, that the accused committed the unlawful act which caused the death of the deceased, and that the accused had the malice aforethought. It is clear from the provisions of section 2 of 3 and the foregoing authority that the key ingredients of murder are as follows: proof of the deceased, that the death was caused by an unlawful act, and that the accused, with malice aforethought, committed the unlawful act which caused death of the deceased. In general criminal jurisprudence, it is right that for a crime to be committed, there has to be a criminal act accompanied by a guilty mind. As correctly observed by Lord Kenyon in Flower versus Paget, and I quote, "To constitute a crime, there must be, as a general rule, both a guilty mind and a criminal act." In other words, the criminal act, otherwise known as the actus reus, and the guilty mind, or the criminal intent, known as nature, must converge for a crime to be committed. For the offense of murder, the actus reus is the unlawful taking of another person's life, while the mens rea is malice aforethought. Malice aforethought is a state of mind that denotes culpability or moral blameworthiness on the part of the person accused of murder. Section 206 of the Penal Code sets out the circumstances in which malice aforethought can be ascertained, and it can be ascertained by proving or establishing any or more of the following circumstances. The first one, an intention to cause the death of or to do grievous harm to any person, whether that person is the person actually killed or not. Knowledge that the act or omission causing the death will probably cause the death or grievous harm of some other person, whether that person is the person actually killed or not. The intent to commit a felony, an intention by the act or omission to facilitate the flight or escape from custody of any person who had committed or attempted to commit a felony. Before addressing the issue as related above for my determination, I think it is important to point out at the outset that in criminal cases, the prosecution bears the burden of proving the guilt of an accused person beyond any reasonable doubt. This burden is anchored on the cardinal principle of the law of evidence as set out in section 107, 1 of the Evidence Act, which states that, and I quote, "Whoever desires any court to give judgment as to any right or liability dependent on the existence of facts which he asserts must prove that those facts exist." As far as criminal cases are concerned, the prosecution's burden of proof is entrenched in Article 50, Sabbatical 2A of the Constitution of Kenya, 2010, which guarantees to every accused person the right to be presumed innocent until the contrary is proved. The standard of proof in criminal cases, which, as I noted earlier, is proved beyond reasonable doubt, was defined defined by Lordeni in the case of Miller versus Minister of Pensions in the following terms, and I quote, "Prove beyond reasonable doubt does not mean prove beyond the shadow of a doubt. The law would fail to protect the community if it admitted fanciful possibilities to deflect the course of justice. If the evidence is so strong against a man and remote possibility in his favor, which can be disputed with the sentence, of course it is possible, but not in the least probable. The case proved beyond reasonable doubt." What that definition means, in my view, is that not every doubt amounts to reasonable doubt as envisaged by the law. From the foregoing, it is clear that reasonable doubt will have been created if, at the conclusion of a trial, the trial court was persuaded to find that there was a real or high probability that the accused person did not commit the offences charged. In such a case, the prosecution would have failed to prove its case against the accused person, and the accused person would be entitled to an acquittal. Having set out the law on what constitutes the prosecution's burden and standard of proof, I now turn to address my mind to the question whether the prosecution has established in this case the essential elements of the offense of murder against the accused persons. Starting with whether the deceased death occurred, and whether or not it was unlawful. From my analysis of the evidence adduced by both the prosecution and the defense, as well as the written submissions filed on behalf of the parties, I found that the death of Sharon was not contested by any of the accused persons. In any event, it was proved through the evidence of PW7, who discovered Sharon's lifeless body near Owade Bridge on 4th of September 2018. It was also proved by the evidence of PW18 and PW19, who collected the body from the scene, and PW29, who identified it to the police pathologist, PW1, who conducted the postmortem. There is therefore no doubt that the death of the deceased occurred. Is whether the deceased's death was lawful or unlawful. In this regard, Article 26, subsection 1 of the Constitution is relevant. This provision guarantees to every person the right to life and proceeds to decree at Article 3 that a person shall not be deprived of life intentionally, except to the extent authorized by the Constitution or other written law. In my view, the import of the above constitutional provision is that there are some homicides which are excusable in law, such as those that are sanctioned by the law. For example, the death penalty, or those resulting from accident or inadvertence. In the case of Mr. Wesonga versus Republic, the court gave guidance on what may constitute lawful homicide, and held as follows, and I quote, "Every homicide is presumed to be unlawful, except where circumstances make it excusable, or where it has been authorized by the law. For a homicide to be excusable, it must have been caused under justifiable circumstances, for example, in self-defense or property." current case, it is clear from the evidence of PW1, that is the police pathologist, that the deceased or the late Sharon died as a result of multiple and severe injuries in the form of deep stab wounds inflicted on different parts of her body, which were mainly targeted at her vital organs, including her abdomen, which housed her unborn baby. According to the evidence of PW1, her death was severe. The cause of her death was severe hemorrhage due to penetrating force trauma with features of manual strangulation. Given this evidence, which was not contested, it is my finding that the prosecution has proved beyond reasonable doubt that the deceased death was not caused by natural causes, and it was not as a result of an accident or inadvertence. I do not therefore have any hesitation in finding that Sharon's death was unlawful. The singular question now left for my determination is whether the accused persons, with malice aforethought, participated in the unlawful killing of the late Sharon. As correctly submitted by a learned counsel representing each of the accused persons, the prosecution's case in this case is solely based on circumstantial evidence. This is so because none of the 42 witnesses who testified in support of the prosecution case gave direct evidence regarding how the deceased met her untimely death. None of them claimed to have witnessed the unlawful killing of Sharon. This being the case, I think it is important to understand what circumstantial evidence entails and the threshold set by the law for it to sustain a safe conviction. Circumstantial evidence is evidence of surrounding facts and circumstances for which it does not directly establish the fact to be proved, but it leads to its proof through a process of evidence. The Evidence Act, Chapter 80 of the Rules of Kenya does not distinguish between direct and circumstantial evidence with respect to admissibility. Both types of evidence are competent and may sustain a conviction if they meet the threshold of proof beyond reasonable doubt. The Supreme Court of Kenya in Republic versus Ahmed Abdul Fatih Mohammed Adanada comprehensively unpacked what constituted circumstantial evidence and its application. I have reproduced some extract from this evidence, which is a long quote, which I think I would not read in the interest of time. It is settled law that for circumstantial evidence to sustain a conviction, it must consist of credible and cogent evidence, which irresistibly pointed to the conclusion that the accused person and nobody else committed the offense charged.